Hello, everyone. Welcome. This is Professor Zayed, and I'm going to be doing another lecture on data protection, data laws and regulations. And I specifically make this type of lectures, like this one here I'm doing tonight, is for one of my classes I teach, data laws. And so this lecture is going to talk about data protection, and then I'm going to be discussing the main areas like European Union and United States data protection laws that exist. I'm going to give a summary of these laws that exist in Europe and the United States. Of course, as we know, there are different countries have different laws and regulations regarding data protection. But before we talk about that, let's just define what is data protection. And when we talk about data protection, we are talking about the ways or the processes of safeguarding or protecting important data from like corruption, compromise, or even like theft, data theft. So there are a set of like strategies that in place that people, that companies, individuals, and organizations and governments can take or can use those strategies to secure the privacy, availability, and integrity of the data. So there's something called CIA triad: confidentiality, integrity, and availability. And so in order to do that, you have to take some actions. Some of those actions are basically, in today's lecture, we're going to be talking about the regulations or the laws that exist. So the two main things that I'm going to be discussing are European data protection regulations, and this is called GDPR or Global Data Protection Regulation. And there's also some U.S. and data protection laws, federal and state laws, that we're going to be discussing these two types of laws here. So let's get started with the European data protection laws or GDPR. And so again, GDPR stands for Global Data Protection Regulation. And what is GDPR is basically a framework that requires businesses to protect the personal data and privacy of the European Union citizens. So regardless of where you do business, regardless of where you are located as a company or a business, if you are outside of the EU, but you handle data of European citizens, you are obliged, you are required to follow these types of regulations, European regulations. So when it comes to transactions, that happens within EU member states. So so again, what is GDPR? It stands for Global Data Protection Regulation, and it replaced something called Data Protection Directive. It was passed in 1995, and the GDPR came on and it was implemented in 2018. So it was passed in 2016, and companies outside of the EU and in the EU were given 2 years to comply with the GDPR regulations. So again, in April of 2016, the European Parliament adopted this GDPR, and they replaced the Data Protection Directive, which was enacted in 1995. So again, the European Union adopted the GDPR on April 27, 2016. And basically, in 4 years earlier, the European Commission proposed the GDPR in 2012. And and then 2016, the European Union adopted that GDPR. They accepted it, and then once they accepted that in 2016, they gave out 2 years for companies to follow through and to be ready to. So from 2016 to 2018 was basically just companies were warned, like Facebook and Twitter and all those companies were told that they have to comply with the GDPR in 2018. So if you remember between 2016 and 2018, you were getting a lot of privacy notices, privacy policy changes from different companies. And this was the reason behind that, was basically because they had to comply. So they had to redo the whole privacy policies to comply with the GDPR. So a lot of companies now are following through and actually following the GDPR. Like, for example, there is Brazil they have their own LGPD, and that's basically data privacy law, Brazilian data privacy law, which is kind of a similar in a way to the GDPR European. So this was also passed in 2018. And then also China and other countries have their own laws as well. So, but here we're talking about GDPR, European Union. So replace the Data Protection Directive. And what is a Data Protection Directive? So basically, that was a law that was passed in 1995, and that was basically outdated. So they had to come up with new regulations that will deal with things like social media and internet and things like that. So that's why the GDPR had to kind of be implemented. So the GDPR defines both processing and personal data broadly. So when we talk about personal data, we're talking about like individual data and things like that, right? Now the directive itself, and then I put a link in the in here in my thing, and I put that in the description. And that's the Directive 1995 of the European Parliament, of the Council. And this is on the protection of individuals with regards to the processing of personal data and the free movement of data. So what does that mean, the free movement of data? It means how the data is being moved around, like storage, for example, where the data is being stored, where it goes, and things like that, right? Because that's one thing that we also need to kind of pay attention to right now with the cloud computing and all the things that we see today, like we see like the internet. A lot of times people store the data on the cloud, but they're not really sure where that data is being stored. And sometimes like you have like an account with one of the cloud providers, you can have your data stored in one data center somewhere, but it might be moved around. So that's basically dealing with that particular issue where your data is being really moved. So again, this is the Directive of 1995 of the European Parliament and of the Council of 24 October 1995. And this is basically deals with the protection of individuals with regards to the processing of personal data and on the free movement of such data. So this was implemented in 1995 and it was outdated by 2012. The European Commission proposed something called GDPR to kind of update this directive. And the one thing about the directive, actually going back to that, is that it was not really mandatory. It was kind of proposal. It was kind of like, some European Union countries didn't really have to kind of follow that. They kind of like, they just can take those directives and they can customize them to their own countries, like on any European member. But the GDPR is kind of required for all European members of the European Union states. So that's one big difference between the directive and between the GDPR. The GDPR itself has a lot of provisions, and it has like a 99 articles. And there's a lot of provisions. Basically, deals with the territorial scope. So what does that mean? It's larger than that of the Data Protection Directive, because by the 2012, 2016, there was a lot more members of the European Union than previously. So, and then personal data processing principles, GDPR explicitly requires data to be processed and basically specifies that inaccurate data must be erased or rectified. That's something new. So if they have inaccurate information about you, that has to be either deleted or fixed or rectified. So again, there also deals with storage limitation principle, like how long and where the storage is, and then legitimate processing bases, including consent. So, and then data subject rights. It deals with some of the provisions, deals with responsibilities, the responsibilities of the company that holds your data, and then record keeping as well. Okay, so now there's a data protection impact assessment. This or DPIA is a new requirement under the GDPR, which did not exist under the 1995 data directive. Basically, this is a new requirement, which part of the protection by design principle. And this is basically requiring companies to conduct data protection impact assessment, right? So this basically means that it's like anything that involves high risk to other people's personal information. So this is so again, the GDPR has a lot of like like a lot of rules, tens of rules, and some of them are old ones, but organization must follow in order to protect the data of the person, about the client or the customer. um, so the data protection, the protection impact assessment, you have to assess the impact or the risk. So this is on the data assessment. Like I said before, there's about 99 articles of the GDPR, and this is article number 35, the data protection impact assessment, and covers the it's a new requirement. So it basically indicates that where a type of processing in particular using new technologies and taking into account the nature and scope, context, and purpose of the processing is likely to result in high risk to the right and freedoms of the person, of the natural person. That's what the GDPR calls natural persons. So this makes it clear that under this law, there are certain conditions that has to be met. So, for example, like they talk about, if you are implementing or using new technologies, you have to do impact assessment. And then also if you are tracking people's locations, as we see now with your devices, your mobile devices, your social media accounts, you can be tracked, your location can be tracked, your behavior online can be tracked as well. And one of the other things they talk about is if you are systematically monitoring a publicly accessible place on a large scale, and then if you also going to be processing children's data, and then if you're going to process personal data related to racial or ethnic origin, political opinions, religious or philosophical beliefs, or trade union memberships, and also if you are processing the genetic data, biometric data for the purpose of uniquely identifying a person. And it also talks about, like I said, if you are going to be processing, if your data processing is used to make automated decisions. So for example, on social media now, they make, decisions based on your behavior on social media and things like that. The other thing is the other provision under GDPR, it talks about data breach notification. And that's basically, it talks about here if there's a data breach, there has been many stories where we hear in the media about data breaches, and what happens if your data is being leaked under a data breach. For example, if you remember a few years ago, there was Equifax data breach, and millions of people's data have been leaked or stolen. So, and GDPR is Article 33, and under the GDPR data breach notifications, it says no later than 72 hours after becoming aware of the data breach. So if a company becomes aware of data breach of their customers, they have up to 3 days to notify the customers. So reading from their article here in GDPR, if you could actually go to gdpr-info.eu, and you'll be able to read the whole regulation under GDPR. And they talk about, in the case of personal data breach, the controller shall, without undue delay and where feasible, no later than 72 hours after having become aware of the data breach, they should notify the personal data breach to the supervisory authority competent in accordance with the Article 55, unless the personal data breach is unlikely to result in a risk to the rights and freedoms of the natural persons. So there are going to be fines if you're not following these regulations. There's going to be fines. We're going to be talking about shortly, and they talk about the processor shall notify the controller without undue delay after becoming aware of a personal data breach. So you have to kind of like prove that you were not aware of this. Let's say this takes like a couple of weeks and the customers were not aware of the data breach, you still have to prove that you were not aware of this. And then enforcement, to enforce these regulations like data breach notifications, for example, it has to be enforced via administrative fines, so up to 20 million euros or 4% of an undertaking's total worldwide annual turnover in a preceding financial year. So that's a lot of money, a lot of fines. If you happen to be convicted of your company convicted of not informing the proper authorities and the individuals of the data breach, you could end up paying up to 20 million euros or 4% of your undertaking's total worldwide annual turnover. So that's a lot of money, especially for companies like Google and Facebook and so on. And there is another provision under GDPR. It's called the right to be forgotten. And this is basically the right to have negative private information about a person to be removed from the internet searches and from other directories under some circumstances. Here, the key word under some circumstances, not under all circumstances. For example, if there is an article written about you online that you want to request, you have the right to go into, let's say, Google, for example, and ask Google to remove that negative article about you from their search engine. But again, you have the right, but doesn't mean that Google is always required to comply with your request. So, and there's a lot of discussions about this. There's pros and cons. Some people agree with this provision, some people don't, and we can discuss some of the reasons why you would you agree with it, why you would not agree with it. So the concept that has been discussed and put into practice both in the European Union and in Argentina, for example, since 2006. So this is the right to eraser or right to be forgotten is in Article 17 under the GDPR. And if you read that, it talks about the data subject shall have the right to obtain from the controller the eraser of personal data concerning him or her without undue delay, and the controller shall have the obligation to erase. Again, shall have the obligation to erase the personal data without undue delay, where one of the following grounds applies. So there are some conditions to this. The personal data are no longer necessary in relation to the purpose for which they were collected or otherwise processed. And another one is another rule is the data subject withdraws consent on which the processing is based according to the point A of the Article 6 in GDPR or point A of the Article 9, where there's no other legal grounds for processing. Again, it talks about other things like the personal data data have been unlawfully processed. So you can have the right to get that data erased if they have been unlawfully processed. And the personal data have to be erased for compliance with legal obligations in union or member of state law to which the controller is subject. And okay, also talks about the personal data have been collected in relation to the offer of information society services. So there are some kind of rules here. You have to kind of one of these grounds has to apply for you to be able to request the data to be erased. And again, to read more about this in Article 17, it's you can go to the gdpr-info.edu, and I put that link in the subscription of this video. Now, so we talked about there is actually like I said, the GDPR has 99 articles, and it's very long to read the whole thing, but I would recommend to kind of go through it in details if you want to know more about GDPR. Now we're talking about laws and regulations in the U.S. So there is a principal data protection legislation. So in the United States, it's a little bit different. So as I said, in the European Union, they have the one GDPR, one law that applies to all member states. But in the US, the regulations are different. So you have some kind of federal laws in the US, and then you have state laws. So a website called iclj.com talks a little bit more about the data protection laws in the United States. And so basically what happens is in the United States, like I said, there are laws that applies to federal laws that applies to all individuals within the United States. but then they have also laws, state laws as well. So it's a little bit different than GDPR. So again, there is no single principal data protection legislation in the United States, like the GDPR, for example. But in the United States, you have hundreds of laws that are enacted on a federal level and a state level, and to protect the personal data of the U.S. residents. And again, talking about U.S. residents, not talking about U.S. citizens. So at the federal level, you have laws like, for example, the FTC or Federal Trade Commission Act, and this is to bring enforcement actions to protect consumers against unfair or deceptive practices, and to enforce federal privacy and data protection regulations. So and then you have like other state laws. You have also a federal law like HIPAA, which is for healthcare. So again, there's no general federal legislation that deals with all laws, like one particular legislation, but like there are multiple federal data protection laws, and they are sector specific. So like I said, you have in the FTC, you have the healthcare laws, HIPAA violation, and then you have also the Video Privacy Protection Act, and so on and so forth. So the federal statutes are primarily aimed at specific sectors. The state statutes are more focused on protecting the privacy rights of the individual consumers of that state. Okay, so the state laws may impose restrictions and obligations on businesses that work inside that state, right? So the U.S. and data protection laws here, the right to privacy is a common law, right, that has been incorporated into the state constitutions of many of the states and into laws and at both the state and the federal level as well. So the laws protecting data and consumer privacy are based on the principle that an individual has an expectation of privacy unless that expectation has been diminished or eliminated excuse me, by agreement, statute, or disclosure. So data protection and privacy statutes in the U.S. are enacted to protect individuals residing in the U.S. or any of the states of the United States. So federal laws apply to protect residents of all states, and then you have state laws that are designed to protect their residents. So if you live in New York, the state laws of New York applies to New York State only. They do not apply to you if you're living outside in New York. So again, many states also adopted the data breach notification, like the GDPR. If you talk about the data breach notification and GDPR, you have up to 3 days or 72 hours to notify the subject or the natural persons, as the GDPR calls it. So they have many of the state laws also have these similar laws as well. So they have, like, let's say talk about some of the states here. You have California, for example. They passed legislation to protect its consumers, restricting disclosure of personal information for marketing purposes, and requires online privacy disclosures, and then granting minor children the right to be forgotten, similar to what we see in the GDPR, under GDPR, and in their online postings. And the state of Massachusetts, they have a strong data protection regulations, and they require an entity that holds, transmits, or collects personal information of a resident of that state to implement and maintain a comprehensive written data security plan. And they have to address 3 designated activities. And those, you can read more about that online. But basically, you have to have a strong security plan. How are you going to be dealing with that? So you also, New York adopted something called the cybersecurity regulations, which is applicable to financial institutions. As we know, New York State has a lot of financial companies, especially in New York City. Doing business in a state which requires comprehensive plans to address cybersecurity risks. In 2019, New York expanded its data breach notification And this will to include express requirements that that entities develop, implement, and maintain reasonable safeguards to protect the security, confidentiality, and integrity of private information. This is according to the website iclj.com. And basically, so when we talk about the confidentiality, integrity of private information, confidentiality basically means that keeping the data confidential, not able to if you have no business seeing that information, only the responsible party be able to see it, or the authorized party to be able to see that data. Integrity means that not able to change that data. So this is what we talk about, confidentiality and integrity. A number of states restricts collection of data from consumers, generally in the context of retail transactions with customers. And this includes limiting the information that can be collected in credit card or check transactions. Most states have enacted legislation that restricts recording communications involving telephones, wiretap laws, or offline, which is eavesdropping laws without obtaining consent. So, for example, that's why some of these applications that that people download on their phones to record conversations, they sometimes they might not work in some states, or they might give you a warning that you're not allowed to record without the consent of the other person. So you have to be careful with that. Again, some states enacted laws specifically protecting children residing in the state. This include the child protection registry laws, which prohibits sending any child under the age of 18 to contact points listed with the registry communications, and promoting any product which the child is legally not permitted to own. So if you're not allowed to, if the child is not permitted to own this product, you're not allowed to market or advertise that to this person, to the child. So purchase, view, process, or use, and requiring operators of online sites that allow children under the age of 18 to post information about themselves to provide the minors a means of deleting all such information upon request. So you have to make that information available on your website, where you can let them know how to make that request to delete that information about you as someone who's under 18 years old. So this is very helpful, to be able to make that available to them. Some of the so we talk about now federal laws or sector specific legislation that impacts data protection. You have a GLBA, or Graham-Leach-Bliley Act, and this particular regulation or law, federal law, governs the protection of personal information in the hands of banks, insurance companies, and other companies in the financial service industry. So this is mainly about financial services, and this statute addresses non-public personal information, which basically means private information, right? So which includes any information that financial services company collects from the customers in connection with in connection with the provision of its services. So the GLBA deals with financial institutions. And then you have the HIPAA, or Health Information Portability and Accountability Act. And if you work in healthcare, you will hear this a lot. Even if you are a patient, you will hear more about healthcare. There are some regulations regarding that, which protects the information held by a cover entity that concerns health status, provisions of healthcare or payment for healthcare, and that can be linked to an individual. Its privacy rule regulates that the collection and disclosure of such information. Its security rule imposes requirements for securing this data. So some of the rules, for example, like if you ever work with a doctor's office, if you ever call them about getting a medical report, they're not going to just mail it to you. I mean, they're not going to email it to you. You might have to log into like a dashboard or a website with an encrypted site where you have a strong password, where you're able to view your personal data, healthcare data. Also deals with like the payment information, because that payment information could also tells people about who you are by just looking at the payment information. So Again, we talked about the Federal Trade Commission Act, and this is a U.S. Federal Trade Commission. Is broadly empowered by the power to bring enforcement actions to protect consumers against unfair or deceptive practices and to enforce federal privacy and data protection regulations. And another federal law is the Driver's Privacy Protection Act of 1994. And this act or this law governs the privacy and disclosure of personal information gathered by state departments of motor vehicles. And the DPPA or Driver's Privacy Protection Act restricts how personal information is released. And this act defines personal information as information that identifies a person. And this is including the photograph, because a photograph will identify you as a person, social security number, client identification number, your name also will identify you, your address, but not the 5-digit zip code is not going to identify you. Your telephone number also might identify you, medical information, and disability information as well. And there's another federal law that called Fair Credit Reporting Act. And this restricts the use of information bearing on an individual's credit worthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living to determine eligibility for credit, employment, or insurance. It also requires truncating credit card numbers on a printed credit card receipts, requires securely destroying certain types of personal information, and it also regulates the use of certain types of information received from affiliated companies for marketing purposes. If you ever go to like a store and you use your credit card and you get a receipt, if you ever look on the receipt, you will find that you're not going to be able to see the whole credit card number on your receipt. It's going to truncate that credit card number. It might have the last 4 numbers of that credit card, and the first numbers up to the last 4 numbers is going to have X's on it. So if you ever look at the receipt, you will see the last 4 of your credit card, but you're not going to see the whole number. That's because of this. You will see that on a credit card because of this act, Federal Fair Credit Reporting Act. So imagine if you take out a receipt and it has all of your credit card number on it, and you throw it out, and somebody looks into the trash and gets able to get your credit card number by just looking at that receipt. So and there is another federal act that is called Unsolicited Commercial Emails, regulated under something called CAN-SPAM Act, and basically it requires certain technical information to be included in unsolicited emails, and then permits consumers to opt out of the receipt of such emails. If you ever receive an email from a company, marketing company, you will notice that you will have the option on that email to be able to unsubscribe from that email. So the way companies do that, the way their companies give you the option to unsubscribe, it's not always in the same location. So some companies or some marketing organizations or some even colleges and so on, when you send you an email, you will look for the word unsubscribe, and that could be on the top left, top right, bottom left, bottom right, in the middle somewhere. But this is required for them to give you the option to click on that email and hit unsubscribe, and that will so for example, if I'm looking at one of my emails, if I click on unsubscribe, it's going to give me the option, are you sure you would like to stop receiving similar messages from this website? And you can say yes, unsubscribe, or you can hit cancel. And some companies, of course, they kind of like make you answer some questions before they unsubscribe you, which is kind of inconvenient, but it's just the way they do it. Like, why are you unsubscribing from our site? You can also click there. Sometimes they give you the option, it says update your preferences. And if you click on that to update your preference, receiving emails, you can say, I don't want to receive email every day. I want to receive it every week, for example. So there are references that you can update in there. But basically the idea is that you should be able to unsubscribe from that email list. I'm just giving you an example, which I'm not. I'm looking at my email on my phone. If I unsubscribe from one of the websites, and I hit update my notifications, it tells me right there, what give me 4 options basically. So it tell me if you like to get announcements about this platform, um, or you want to get announcements about the premium subscription, or you want to get special offers. You can check that if there's special offers from third parties, or you can just say uncheck that to update that. So I'm looking at one of the sites, and it says here it has different options. It has general announcements if you want to update that, discussions, and so on and so forth. So one of the other options is your content edits, your content are accepted. So if you, this is one of the sites that I subscribe to for uploading research papers and so on. So this is also under this law that you can unsubscribe. And if you don't see that option, what I usually tell people to do is, if you click on an email and it doesn't have the option to unsubscribe, what you can do is you can click on report spam, and that most likely a spam email that you did not really subscribe to. You can just click on it to make it a spam, and you should not be able to see that email again in your inbox. And then there's another act here called the Telephone Consumer Protection Act, or TCPA, and associated regulations. Regulate all calls and text messages to mobile phones, and regulate calls to residential phones that are made for marketing purposes or using automated dialing systems or pre-recorded messages under the telemarketing sales rule. I remember years ago, there used to be an option that they require companies they have this do not call list. You can actually call the number and say, I don't want to receive any advertising marketing calls. But we still receive those calls because some of those calls are coming from outside of the United States. It's kind of hard to prevent those calls. But under this regulation is that it regulates calls and text messages to mobile phones, and regulate calls to residential phones as well. And there is another act, federal act, is Children's Information. The COPA, which is basically protects the children's information at the federal level. And this is called the Children's Online Privacy Protection, or COPA. And this act prohibits the online collection of any information from a child under the age of 13. And this requires publication of privacy notices and collection of verifiable parental consent when the information from children being collected. And this is not the same thing as the other act that I mentioned earlier about children, which is, I'm going to bring that one here. There was one of the other acts that talks about under 18, but this is actually a little bit different. Okay, and see, children. And there's another one called the Video Privacy Protection Act, and this was enacted to protect wrongful disclosure of videotape, rental or sale records, or similar audiovisual materials, or online streaming. Again, you can see some of these terms and some of these that mentioned in some of these acts are kind of outdated, talking about videotape. That's why many people recommend that, or I'm one of the people actually who hope to see one day that the federal law like GDPR in the United States, they have some kind of a law in the United States that's similar to the European GDPR, where just everything is under one, like you have different articles that deals with different industries, but just one regulation. Many countries are following the footsteps of the GDPR, European Union, but not the United States. California, for example, is kind of taking steps closer to GDPR on their state level. And then you have also the FTC, the Office of the, so here talking about the authorities responsible for data collection, some of the federal governments, organizations. You have on the federal level, you have the FTC, or Federal Trade Commission. You also have the Office of the Comptroller of the Currency, and then you have the Department of Health and Human Services. and you can predict what, when we talk about Department of Health and Human Services, what type of law, federal law, that they be dealing with, which is basically the healthcare or HIPAA. So these are some of the laws. We talked about GDPR. We talked about European laws. Again, the GDPR, what stands for General Data Protection Regulation, or protection rights, or regulation, but they are rights. They seek the protection of data and privacy of individuals residing within the content European Union. And so they have some different rights, like, for example, the right to be informed, the right to be forgotten, or the right to eraser, the right to the right of access, which basically means the right to access your data, and the right to rectify the data. So if there's data has been false data about you, that you have the right to rectify that data, and the right to object, and things like that. So again, as I mentioned, this GDPR was implemented, was proposed in 2012, and by the European Commission, and it was adopted by the European Parliament in 2016, and it was implemented, or took effect in 2018. And so it's you have the federal laws in the United States, you have state laws. So I'm going to be posting some links to GDPR and the federal laws in the United States for you to read more about them. So again, thank you for listening, and see you in the next video.